going to do it. Task force will come to order. I'd like to welcome everyone to the first hearing of the Judiciary Committee's Over-Criminalization Task Force. This is the first in a series of hearings the task force will hold on the growing problem of over-criminalization and over-federalization. The Crime Subcommittee had hearings in both the 111th and 112th Congresses to resurrect important policy discussions that had been dormant for over 2 decades about the breadth and scope of the federal criminal law. Our work continues today. The objective of today's hearing is to define the scope of the over-criminalization problem. That, in and of itself, is a complex and challenging task. At present, the United States Code contains approximately 4,500 federal crimes, as well as innumerable regulations and rules, many of which carry severe fines and jail time for violations. Then there is no indication that Congress is slowing down. Indeed, over the past 3 decades, Congress has created an average of 500 new crimes per decade, and the Administrative Office of the U.S. Courts estimate that over 80,000 defendants are sentenced in federal courts annually. Many of the crimes on the books are antiquated or redundant. Some are poorly drafted, and some have not been used in the last 30 years. Moreover, many of the regulatory crimes in the Code lack any mens rea, the intent to commit a crime. That means that an American citizen may not only be unaware that he is committing a crime, but he may be held strictly liable for his conduct. In the 109th Congress, 203 bills were proposed containing some 446 nonviolent crimes. It's hard to imagine that there still remain nearly 500 types of legitimate criminal conduct that Congress has failed to properly prohibit. Accordingly, the task force will examine the types of conduct Congress has criminalized to assess several important issues. Should the conduct be criminal? If so, to what extent should it be punished? Is the offense properly written to distinguish criminal from lawful conduct? The need for reform becomes particularly apparent when you read the stories of well-meaning Americans whose lives have been turned upside down when they run afoul of an obscure federal statute, rule, or regulation. In Virginia, a little girl saved a woodpecker from the family cat and was fined $535 because under the Federal Migratory Bird Act, it's a crime to take or transport a woodpecker. In Texas, a 66-year-old retiree had his home raided by a SWAT team and spent almost 2 years in prison because he didn't have the proper paperwork for some of his prized orchids, all of which were legally imported. The judge who sentenced him to prison said, "Sometimes life hands us lemons." But the source of the sourness was the government. This task force is an overdue effort to address this problem. We will focus on reforms to streamline our criminal code, reviewing federal laws in Title 18 to modernize our criminal code, and addressing the codification of crimes outside of Title 18 that have not gone through the Judiciary Committee. We will examine the extent of the problem and make recommendations to the full committee on how to effectively address these issues. I look forward to working with my task force colleagues on this bipartisan effort, and it is now my pleasure to recognize for his opening statement the ranking member of the task force, the gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Today's hearing about over-criminalization of conduct and over-federalization of criminal law comes after a series of conversations and hearings have taken place over the last 2 Congresses. Members of the Crime Subcommittee have met with a coalition of organizations, some of whose leaders are with us today. These and other organizations have come to Congress to seek consideration and review of the practice and process of enacting federal criminal law, and they've come out of a concern for what they and many others view as an explosive rate of growth of the federal criminal code. They also have questions about the wisdom of continued expansion of the criminal code without first taking time to consider and review the process by which crime legislation is enacted. Their concern is valid. The U.S. Criminal Code has dramatically increased in size and scope since it was last recodified about 50 years ago. There are an estimated 4,500 federal crimes in the code today, and according to a study by the Federalist Society, the number of federal offenses increased by about 30% between 1980 and 2004. We're averaging almost one new crime a week over the past few decades. In the top 4,500 provisions of the Federal Criminal Code, there are an estimated 300,000 or more federal regulations that can be enforced with criminal penalties. Far too many of these criminal offenses and regulations lack the adequate criminal intent or mens rea requirement to protect the innocent. Some offenses have no intent requirement at all. Historic and groundbreaking joint study and report released by the National Association of Criminal Defense Lawyers and the 2010 Heritage Foundation report, Without Intent, took a look at the federal legislative process for nonviolent criminal offenses introduced in the 109th Congress. That's 2005-2006. The study revealed that offenses with inadequate criminal intent requirements were present throughout all stages of the legislative process. Over 57% of the offenses introduced and 64% of those actually enacted into law contained inadequate criminal intent requirements, putting the innocent at risk of criminal prosecution. The study also commented on poor legislative draftsmanship, citing legislation as being vague, far-reaching, and having inadequate mens rea requirements. The consequence of this will lead to unjust prosecutions, convictions, and punishments. So I look forward to hearing today's witnesses' suggestions regarding methods of improving legislative draftsmanship. And where crime is primarily a matter of state and local law, over the past 40 years, Congress has increasingly federalized crimes already covered by state law. Not surprising, this dual federal-state prosecution authority not only creates tensions between the government entities, but also places an individual in an extremely negative and precarious position of being forced with prosecution either at the federal or state level. The bottom line is that an individual's fate is often hinged on not the actual offense, but the authority that prosecutes them. It will be the challenge of this task force to explore and resolve the impact of over-federalization in the area of other crimes, including but not limited to such crimes as carjacking and drug offenses. An unforeseen consequence of over-criminalization and over-federalization has been over-incarceration, with explosion in growth in the U.S. prison population. The number of federal prisoners in 1980 was 25,000, but it's over 200,000 today. It is this number, when added to the incarceration of those incarcerated in state and local jails and in prisons, has resulted in the United States now being the largest incarcerator in terms of both the total number incarcerated and the rate of incarceration. In the last 30 years, we've gone from an average daily jail and prison incarceration level of about 500,000 to over 2 million, with an average incarceration rate of over 750 per 100,000 residents, a rate about 7 times the international average. China, by contrast, with 3 times as many people, has a total incarceration level of 1.5 million, with a rate of about 117 per 100,000. And we look to minorities, it's even worse. The average lockup rate for African Americans is around 2,200. 10 states, the rate is almost 4,000. That is particularly egregious because of a report from the Pew Center on the states. They did research and found that any incarceration rate over 350 per 100,000 gives diminishing returns, and at 500 per 100,000 actually becomes counterproductive, meaning that it actually generates more crime than it stops by messing up so many families, wasting so much money on prisons, having so many people in the area with criminal records. The work of this task force begins today, and it will involve identifying improvements in the Federal Criminal Code that we can all agree on. This work is extremely important and must be done correctly and effectively. It will require a major commitment of time and attention and must involve participants and input not only from members of both parties of the House and Senate, but also from a diverse gathering of interested parties, including the organizations in the over-criminalization working groups and others. We'll need the help of criminal law researchers, federal law enforcement community, representatives of the judiciary, including the U.S. Sentencing Commission and the administrative offices of the courts, and other interested organizations and professionals. So I look forward to working with my colleagues in the task force and look forward to our witnesses today, particularly Attorney Benjamin, who's one of my constituents. Thank you very much.
Thank you. The gentleman's time has expired. The chair recognizes the chair of the full committee, gentleman from Virginia, Mr. Goodlatte.
Thank you, Chairman Sensenbrenner. I'm very happy to be here today at the introductory hearing for this bipartisan over-criminalization task force. Today's hearing will afford members of the task force the opportunity to hear from a distinguished panel of outside experts who have been studying this issue very closely for a number of years. The number of federal crimes has exploded in recent decades, bringing the number to approximately 4,500. According to a study by the Federalist Society, the number of federal criminal offenses grew by 30% between 1980 and 2004. Congress added 452 new federal criminal offenses between just 2000 and 2007 alone, which averages 56.5 new crimes per year. This pace is simply unsustainable. Perhaps more concerning than the sheer number of offenses is how Congress has written many of these new crimes. The recent growth of the federal code in all areas of life has brought with it an ever-increasing labyrinth of federal regulations, many of which also impose criminal penalties without a showing of mens rea or criminal intent. A troubling example of this is what happened to three-time Indy 500 winner Bobby Unser. When snowmobiling near his home, an unexpected snowstorm forced Unser and a friend to seek refuge in a barn. While trying to escape the storm, they unwittingly went into a national forest wilderness area. They spent 2 days and nights in sub-zero weather, eating snow to slake their thirst before being rescued. Following his safe return home, Unser then contacted the Forest Service to help retrieve his snowmobile. For his trouble, he was later convicted of unlawful operation of a snowmobile within a national forest wilderness area, which carried a maximum penalty of 6 months in prison and a $5,000 fine. I am confident Congress never intended to subject someone in Unser's situation to criminal liability. Excuse me. However, stories like this have become all too typical. I look forward to hearing from our witnesses today and in the coming months about the scope of over-criminalization and over-federalization and what steps this task force and the Judiciary Committee can take to address the issue. Concern for this issue is bipartisan and requires bipartisan perspectives. I commend all of my colleagues here today for your work on the task force, and I yield back the balance of my time.
The gentleman from Michigan, Mr. Conyers, the ranking member of the full committee, is recognized for his opening statement.
Mr. Chairman, everybody has said already what I was going to say again, and so I'll submit my statement for the record and salute the task force, congratulate the witnesses for joining us, and yield back the balance of my time.
Without objection, the gentleman from Michigan's statement will be included in the record, and without objections, all members' opening statements will be included in the record at this point. The chair will now introduce the four witnesses. The first witness is the Honorable George Terwilliger III. He is a partner in Morgan Lewis's litigation practice and co-chair of the white-collar litigation and government investigations practice. In this capacity, Mr. Terwilliger provides counsel in litigation, internal investigations, and enforcement proceedings. He has served as a U.S. presidential appointee in 2 administrations. He was appointed U.S. Attorney by President Ronald Reagan and served as Deputy Attorney General and Acting Attorney General in the George H.W. Bush administration. Most recently, Mr. Terwilliger was a partner in the white-collar practice of another international law firm. He received his bachelor's degree from Seton Hall University and his law degree from the Antioch School of Law. John Malcolm is the Rule of Law Program's Policy Director and the Ed Gilbertson and Sherry Lindbergh Senior Legal Fellow in the Edwin Meese III Center for Judicial Studies of the Heritage Foundation. And in this capacity, he writes and speaks on a variety of law-related topics. Previously, he served as an Assistant U.S. Attorney in Atlanta and as an Associate Independent Counsel in Washington, D.C. Mr. Malcolm then went on to serve as a Deputy Assistant Attorney General in the Criminal Division of the Department of Justice. He was an Executive Vice President and Director of the Worldwide Anti-Piracy Operations for the Motion Picture Association of America and went on to serve on the faculty of Pepperdine School of Law as a Distinguished Practitioner in Residence. Mr. Malcolm was most recently the General Counsel at the U.S. Commission on International Religious Freedom. He is a graduate of Columbia and Harvard Law School. William N. Shepard is testifying in his capacity as a member of the American Bar Association. He is a partner at Holland and Knight. In this capacity, he represents individuals and corporations in the state and federal government investigations and grand jury investigations. Previously, he served as a prosecutor in Miami and then as the statewide prosecutor of Florida. He is chair of the American Bar Association's Criminal Justice Section, a member of its Global Anti-Tax Corruption Task Force, and a former division director of its White Collar Crime Division. He received both his undergraduate and law degrees from Georgetown. Stephen Benjamin is president of the National Association of Criminal Defense Lawyers, which is a professional bar association founded in 1958. Its members include private criminal defense lawyers, public defenders, active duty U.S. military defense counsel, law professors, and judges committed to preserving fairness within America's criminal justice system. He is in private practice at the Virginia firm of Benjamin and is at Desportes or Deport? Desportes, okay. He served as special counsel to the Virginia Senate Courts of Justice or Judiciary Committee and is a member of the Virginia Board of Forensic Science and the Virginia Indigent Defense Commission. He previously served as president of the Virginia Association of Criminal Defense Lawyers. So we will now proceed under the 5-minute rule. We are facing a very long series of votes this morning, and we don't know when it will start, so I will ask each of you to try and wrap it up in 5 minutes, and you all know about the green, yellow, and red lights. Without objection, all of your full statements will be included in the record at the point with your verbal testimony, and Mr. Terwilliger, you are first.
Thank you, Mr. Chairman and Ranking Member Scott, Chairman Goodlatte, Ranking Member Conyers, and members of the task force for having me here today and inviting me to join with you in discussing the subject of over-criminalization and over-regulation.
Is your mic on, Mr. Terwilliger?
Yes, sir.
Okay.
I believe that the work of this task force has taken on even greater importance than it had when the task force was originally initiated. Recent events have vividly brought home to many Americans an understanding that their most fundamental liberties are at risk due to the overpowering and overburdening reach of the federal government establishment. I am not referring to the recently reported NSA counterterrorism programs, where I recognize the unfortunate need for these programs due to the significant terrorist threat our people face at home and abroad. Rather, it is something far more insidious and uncontrollable than NSA programs that impinge on Americans' liberties today. The recent events concerning the reprehensible and possibly thuggish conduct of the IRS is but one stark example of a federal government that reaches far too deeply and intrusively into the daily lives and choices of ordinary Americans. We've lost sight of the fact, in my view, that the purpose of our Constitution is not so much to establish a government as to ensure that the government that we must have is never permitted to take any more of our personal liberties from us than is absolutely necessary. We are on a path that is taking us from a system of ordered liberty through the rule of law to one of liberty that is only as extensive as government fiats allow. And what freedoms are in peril? They range from the most fundamental of personal choices to others that, standing alone, may mean less, but considered collectively, illustrate that the certain surrendering of personal liberty continues. Consider the freedom of each individual to retain the fruits of his or her labor and decide how, when, and for what to use those funds. Instead, we have a system of taxation that takes more and more from a few to distribute to many. That should not be, at least on the present scale, a choice that is made by government. Liberty is further threatened because one of the results of massive and often wasted runaway federal spending is that the government is starved for the funds to do the things that are its core functions and responsibilities, most especially those related to national defense and public safety, but also including those needed to foster expansion of economic freedom that produces prosperity. The federal Leviathan even reaches into our daily life so far as to dictate to us when we awake in the morning what kind of light bulb may illuminate our bathroom and how much water can flow through our shower head. This would be humorous, if not such a sad commentary on what we have allowed to evolve. Over-criminalization is part of this larger picture. Thus, efforts by Congress to get its arms around these issues, such as through this task force, are a most significant step forward. My prepared statement traces the origins and developments of the use of federal criminal law and addresses how we have strayed from its fundamental purpose. But I believe the fundamental takeaway is this: we have lost sight of the proper use of federal criminal law as a carefully applied tool to protect the means and instrumentalities of commerce, a goal in harmony with the principles of federalism and the framers' intent. I would like to leave you today with one simple idea that I think could be a significant step forward. We could assure ourselves that no person or business is ever convicted of a criminal offense unless a jury has determined that he, she, or it acted with criminal intent. And I believe this could be accomplished by writing an overriding provision of law that requires as an element of any offense where a showing of intent is not expressly required, that it be proven beyond a reasonable doubt that the defendant acted with a bad purpose, that is, with the intent to disobey or disregard a requirement of law. This could eliminate any question as to strict criminal liability offenses being actionable and would reintroduce to federal criminal law the fundamental and venerated principle that a criminal offense must include proof of intent to do a bad act. Again, I thank the chair and the ranking member of the task force for taking on this important work, and will be pleased to answer any questions or to discuss these issues with members or staff anytime.
Thank you, Mr. Terwilliger. Mr. Shepard?
Thank you very much, sir. Mr. Chairman and Ranking Member, it's a pleasure to be here on behalf of the American Bar Association. I serve as chair of the American Bar Association's 20,000-member criminal justice section, a group that's made up of both prosecutors and defense lawyers, judges and academics, who, like you in this bipartisan setting, often find themselves... I believe it's on. Oh, there we go. Thank you very much, sir. Who find ourselves, as you do, addressing these issues in a bipartisan fashion. We, from our diverse professional backgrounds, come to the same conclusions that you do. There are too many criminal laws. The enforcement of many of these laws becomes confused, and because of the overburdening number of laws and the strain that puts on our system, priorities, which we might all agree on, oftentimes get sidetracked because of fiscal realities. My own practice background is that I spent 12 years as a state court prosecutor, trying cases in courthouses in Miami and throughout the state of Florida. For the last 4 years of that service, I had the opportunity to serve as Florida's statewide prosecutor, and at which point I spent a fair amount of time in our legislative process in our state legislatures. One of the issues that became apparent to us as a security threat was a growing problem of gangs in the state of Florida. We worked with legislative leaders to address some of the issues and craft new laws that would help give law enforcement tools they might better use to protect the citizens of our state. As that debate went on, one of the main issues became, well, Mr. Shepard, if we pass some of these, it will have a significant prison bed impact. Well, yes, that was the goal, to have a prison bed impact as it related to serious gang violence and gang offenders. But Mr. Shepard, you don't understand. We have a large influx of new inmates who are traffic offenders, not trafficking, driving offenses. And I'm not trying to minimize the importance of those, but I think it illustrated the point that as new penalties get added on to new statutes, perhaps without thinking about the long-term impact, some of those decisions have an impact on what we would prioritize. If we are going to build prisons, certainly we would build them to protect our communities from violent gang offenders. And if our own fiscal realities have been dictated by something else, I think that's a prime example on a broader spectrum of some of the same issues that states are facing as you're trying to discuss these issues today. The American Bar Association has long been in favor of policies that would bring sensible reforms to some of the legislative issues. One that I'll talk about as it relates to an individual case that I was involved in recently and drafting an amicus brief on behalf of my colleague here at the National Association of Criminal Defense Lawyers, involved a commercial fisherman in Tampa who was prosecuted under a crime drafted by this Congress. But my guess would be that Congress had no idea that a post-Enron anti-document shredding statute would be used to convict a man of destroying 3 red grouper. A 4-day federal court trial resulted in his conviction for the destruction of this evidence that he had been sent by the Fish and Game Commission to take to the port. When they came back to the port 3 days later to re-inspect the fish, their original count of 72 reflected there were now only 69 fish on the port. That case is now before the Court of Appeals in the 11th Circuit. And I'm not here to argue the case, but what I am here to say is that the laws that you draft get applied by real people and impact real lives in ways that you may have no idea would be the ultimate goal and the ultimate use as it impacts those individual people. If laws are important enough such that individual men should spend time in federal prison, those laws should be drafted by you, the people in this Congress, instead of delegated to career people who work in agencies who are not elected officials like yourself, people who have a narrow focus and perhaps don't have a broader perspective that you carry with you when you come from your constituents. So in concluding, I would just say that if it's important enough to send a man to federal prison, it's important enough for this Congress to vote on it. And I think that that's an overarching issue that you can all address in this, and I compliment you for your work in this area. Thank you.
Thank you very much, Mr. Malcolm.
Chairman, members of Congress, thank you for providing me the opportunity to speak to you about over-criminalization, a term used to describe the overuse and misuse of criminal law in today's society. In my capacity as the Rule of Law Program's Policy Director at the Heritage Foundation, I host regular meetings of an over-criminalization working group consisting of several organizations from across the political spectrum. These organizations don't agree on very many issues, but they do agree on this. Over-criminalization is a serious and growing problem and needs to be remedied. I've also spent much of my career as a prosecutor and a criminal defense attorney, so I speak to you as someone with experience on both sides of the courtroom. For most of our nation's history, all of the crimes, and there weren't very many of them, were malum in se offenses. That is, they prohibited conduct that was widely recognized as morally blameworthy. Today, however, buried within the 51 titles of the United States Code and the far more voluminous Code of Federal Regulations, there are approximately 4,500 criminal statutes and another 300,000 or more criminal regulations, and scores more are created every year. Many of these laws, unfortunately, contribute to the over-criminalization problem. Many federal criminal laws duplicate other existing federal and state criminal laws. Some federal laws increase the penalties for certain crimes without any demonstrated need, adding to the taxpayer's burden. Most of these new laws, usually in the form of regulations, are malum prohibitum offenses, which are crimes only because Congress or some regulator has said that they are, not because they are inherently blameworthy. Unlike malum in se offenses, which prohibit morally indefensible conduct, regulations actually allow conduct, but they circumscribe when, where, how often, and by whom certain conduct can be done, often in ways that are very hard for the non-expert to understand. When criminal penalties are attached to violations of obscure regulations, over-criminalization problems often ensue. But there's an even bigger problem. Today, many criminal laws lack an adequate or any mens rea requirement, meaning that a prosecutor doesn't even have to prove that the accused knew that he was violating a law in order to convict him. Many of these so-called offenses are so arcane or incomprehensible that a reasonable person wouldn't have any idea that what he was doing was a crime. And there are other problems, too. If somebody wanted to find out whether his proposed conduct was illegal, there was no convenient, easily accessible place that he could go to in order to find a complete list of federal crimes. Moreover, the criminal code today is so vast and complex that judges and lawyers have a lot of trouble discerning what's legal and what's illegal. What hope do ordinary citizens have? It's inevitable that many morally blameless individuals will end up committing acts that turn out to be crimes, and some of them will end up in prison. The Heritage Foundation's just come out with a booklet entitled USA versus You that provides the stories of just a few unfortunate people who got caught up in the web of overcriminalization, and there are more such stories on our website. When we divorce legal guilt from moral blameworthiness and place excessive reliance on criminal law to address social problems rather than the administrative or civil justice systems, problems occur. When morally blameless people unwittingly commit acts that turn out to be crimes and are prosecuted for those offenses, the public's respect for the fairness and integrity of our criminal justice system is diminished, which is something that should concern everyone. There are a number of proposals that I would encourage you to consider, such as passing a default mens rea provision for crimes in which no mens rea has been provided, and passing a law requiring the government to identify every federal crime and to post it in a manner that is easily accessible to the public at no charge. I look forward to future hearings in which these and other proposals are discussed in greater detail. And with that, I'd be happy to answer any questions you might have.
Thank you very much, Mr. Benjamin.
Thank you, Mr. Chairman and Ranking Member Scott. My name is Steve Benjamin, and I am the president of the National Association of Criminal Defense Lawyers. And on behalf of NACDL, I commend the House Judiciary Committee for establishing this Over-Criminalization Task Force. As a practitioner from the Commonwealth of Virginia, I am personally grateful for the leadership and support of two members from my own congressional delegation, Judiciary Committee Chair Goodlatte and Task Force Ranking Member Scott, whose work on this critical issue demonstrates that the danger of over-criminalization transcends the traditional ideological divide. The problem you confront is not abstract or theoretical. Over-criminalization directly impacts commerce, free enterprise, and innovation, but it is not just a problem with white-collar implications. It encompasses policies and practices that affect every person in society, and in my written testimony, I have provided numerous examples. The fact is, we have become addicted to the use of criminal law as a blunt instrument to control social and economic behavior. As a result of overcriminalization, the United States has more prisoners than any nation on earth, and an estimated 65 million Americans are now stigmatized by a criminal conviction and the collateral consequences that increasingly result. This is not because we are a country of lawbreakers or criminals. It is because we use the federal criminal law for regulatory purposes far beyond the traditional purpose, exercised historically at the state level, of deterring and punishing criminal conduct. A fundamental question before this task force is whether the body of federal crimes should continue to expand, and to answer this question requires acknowledgement that where Congress has created new crimes, it has done so poorly and without regard for whether those new crimes reach conduct that represents genuinely bad behavior. Congress often fails to speak clearly and with the necessary specificity when legislating criminal offenses, instead enacting overly expansive and poorly defined criminal laws which lack clear requirements of criminal intent. With rare exception, the government should not be allowed to punish a person without having to prove he acted with wrongful intent. When the average citizen cannot determine what constitutes unlawful activity in order to conform her conduct to the law, that is unfairness in its most basic form. Further, Congress often delegates to its criminal lawmaking authority to executive branch agencies and officials. Regulatory agencies are empowered to unilaterally enact massive criminal provisions with little oversight. As a result, the legislative branch has ceded the ability to limit the weighty economic, social, and individual costs of the entire criminal justice system. Poorly written laws and weak intent standards have jeopardized the fundamental protection of a trial, Unlimited discretion over charging decisions, combined with mandatory minimum sentences and high sentencing guidelines, afford prosecutors the power to deter the accused from asserting their innocence or testing new laws before a jury of their peers. Rarely will the right to trial justify the risk of a harsh sentence if a more favorable plea agreement can be struck. Lastly, overly broad laws combined with weak intent requirements allow the criminal law to be improperly used to pursue what otherwise would be resolved by civil claims or penalty. Both government and corporate entities resort to the threat of criminal sanction to extract civil judgments and forfeitures, eliminate competitors, and improperly control behavior. Of special concern to NACDL is the fact that the government's expenditure on federal law enforcement significantly outpaces its spending on the defense function. It is inexcusable that during this 50th anniversary of Gideon versus Wainwright and the right to counsel, our indigent defense system is in crisis. That crisis has long afflicted the states, but now budget cuts imperil the federal indigent defense system, even as resources for the prosecutorial function flow unabated. This imbalance imperils the integrity of the criminal justice system. To conclude, we encourage this task force to consider the passage of a law that would apply a criminal intent requirement by default to laws that lack one. And while the enactment of criminal penalties does have a certain allure, the true and tremendous cost of doing so means that an assessment of impact should be a condition of enactment. The position of NACDL and its purpose in testifying here today is clear. The criminal defense lawyers of this nation value and seek a criminal justice policy for America that ensures fairness, due process, and the equal protection of the law while providing compassion for the victims and witnesses of crime, the protection of the innocent, and the just punishment of the guilty. We are inspired by your bipartisan efforts and will support and assist you however we can.
I'd like to thank each of the witnesses for very excellent testimony. I think that all of the members of the task force agree with all of you and amongst ourselves. This is a vast undertaking, and we are operating under somewhat of a time limit because the life of task forces are supposed to be 6 months, but I would guess that when we get toward the end of the Congress, we're going to ask for a re-upping on this because this is not going to get done in 6 months. The staff has asked the Congressional Research Service to update the calculation of criminal offenses in the federal code, which was last undertaken in 2008. CRS's initial response to our request was that they lacked the manpower and resources to accomplish this task. And I think this confirms the point that all of us have been making on this issue and demonstrates the breadth of over-criminalization. The task force staff is going to meet with CRS to figure out how to resolve this problem so that at least we can see what we're doing and where the problems are so that we can get a dragnet, pun intended, of the criminal laws both in the code as well as in federal regulations. Now, that being said, I would like to ask each of the witnesses to give us your priorities, just in a phrase, since I've got a limited amount of time, on where we ought to start on this, whether it should be over-criminalization versus over-federalization, mens rea, Section 1811, administrative criminal penalties and the like. And Mr. Terwilliger, I guess you're first, and we'll go down the panel.
Thank you, Mr. Chairman. And recognizing the brevity of time, I'd be happy to expand on this later, but I think there should be two priorities. One, because it is of great importance in terms of both the reality and the perception of the fundamental fairness of the federal criminal justice system, is to address the intent issue, which each witness here has raised in one form or another. Nobody should be convicted of a crime that doesn't have the intent to do something that the law forbids, and ought to have an opportunity to test whether that intent is there in an adversarial proceeding.
Okay, I've got a limited amount of time, so So,
The second priority, I'll just, one phrase,
Okay.
is on the over-regulation because it's stifling economic expansion and development to
Okay.
American corporations.
okay, mens rea and over-regulation. Mr. Shepherd.
And I'd agree that mens rea is number one, and number two, overregulation, but the way I would phrase it is we have taken Chevron deference, where the courts encourage us to look at the expert regulators, and expanded that to Chevron prosecution. And I think that's really the fundamental the problem here. But
Oh.
mens rea one and Chevron
Okay,
prosecution
Mr. Malcolm.
number two.
Yeah, I'd certainly default mens rea would be my top priority. I would echo what Mr. Terwilliger, Mr. Shepherd have said. You know, I think that's a good list. You know, my general belief is that if it's something that's important enough that somebody could go to jail, it's something you ought to vote on and not have a regulator implement.
I would agree with that. Mr. Benjamin.
Well, what they said. Mens rea and overbreadth, I would add.
Okay. Thank you very much. I yield back the balance of my time. Gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Let me follow through on that because everybody has talked about enforcing regulations with the criminal code. What about regulations that involve serious safety and health regulations? Violation of those, shouldn't they be criminal? If you have people who are putting workers, for example, in life or death situations. Mr. Dwinger.
I suppose there could be a reservation for the most egregious kind of conduct of that nature, but in general, Mr. Scott, that slippery slope is how we got here, respectfully. And I think there are more than adequate civil remedies to actually affect the way businesses, for example, behave. Something on the notion of intentional conduct that, for example, recklessly disregards a known standard of safety that puts a worker in danger, that might be a criminal, a reservation for a criminal offense. But we've gone way beyond that standard at this point, in my view.
Well, we're talking about getting rid of all of them, and some of them we might want to reserve for the reasons you've articulated.
Yes, sir.
Would there be if you didn't know about the regulation, but you put your workers in danger of life and safety?
Well, that goes
without a mens rea?
comes back to the intent issue and whether or not, and that's why my formulation would be to proof of intent would require a showing of a purposeful disobeying or disregarding a law. We have the notion of turning a blind eye to the requirements of the law, consciously avoiding knowing what the law requires. If it's within someone's responsibility to know what the law requires and they don't undertake to at least minimally understand what that requirement is, that may be enough to support a conviction, assuming those other elements are present.
Mr. Malcolm, you want to comment on that?
Yeah, I do. Mr. Scott, if Congress blesses a regulation prohibiting this sort of conduct and notice is provided to affected parties, then it's fine to make it a crime. If the conduct is clearly blameworthy and intent is proven, there's nothing wrong with making this a crime. However, if that is not the case, there's no reason why, even if a harmful result occurs, that such conduct cannot be addressed effectively, indeed harshly, by both the civil justice system and the administrative system. That way, the harm can be remedied, general deterrence message can be sent out, and you're not branding somebody as a criminal. Well,
was reckless disregard of life and safety enough?
Well, reckless disregard is an intent standard, and on the realm of intent standards.
And what about disregard if it is within your responsibility to know and you just didn't bother to find out what the regulations were?
Well, generally, if it's a highly regulated industry, the government ought to do a better job about letting those industries know what is prohibited. But if it's reckless disregard of a known danger, then generally there's nothing wrong with criminalizing that, and Congress has done so and blessed that on a number of occasions.
Does somebody want to comment on when it should be a federal criminal law rather than a state? Most of the federal criminal code just overlaps state laws. I mentioned carjacking. Why should that be a federal law, and why should we leave most of this stuff to the states?
I'd be glad to address that, sir. My own background, as I told you, is as a state prosecutor. Most of the cases that we prosecuted, whether they were individual defendants or racketeering cases against large groups of violent gangs or large white-collar crime cases, could have easily been filed in federal court. I agree, there is a large duplication of that. Oftentimes there's a balancing between prosecutors and law enforcement to figure out where do we have more leverage against the defendant. Do we have a better sentencing structure for this particular crime on state court or federal court? Are there evidentiary rules in state decisions that support the prosecution in this versus the other? So that's how the leverage develops.
Mr. Benjamin, what does that do to a defendant having to look at both federal and state, and why should we have the overlap?
Well, the practical effect is that it makes his legal fee unattainable. Just nobody can afford private counsel because the consequences are so severe and far-reaching. That's a very real practical effect. But one of the benefits to deferring to the states is that is one of the benefits of federalism, permitting each of the 50 states to decide for its own what conduct within that state should be criminal and what penalty should attach. That is one of the reasons for our federalist structure.
Thank you.
Gentleman's time has expired. The gentleman from North Carolina, Mr. Holding.
Thank you. I'm sure we all appreciate the distinction and abilities of our panelists today, especially my friend, Mr. Terwilliger. It's always a pleasure. Yesterday, Director Mueller testified before the committee and talked about the priorities of the FBI and noted with sequestration and declining budget and budget cuts that you really have to sharpen up what your priorities are. And as a criteria, you have to prioritize things where federal law enforcement brings something extra to the table, something unique about federal law enforcement. That's why we should devote FBI resources to enforcement. So, Mr. Terwilliger, what areas of current federal law now, criminal law, do you think that federal resources ought to be devoted to if you had to prioritize?
I think clearly the threat of terrorism, both now more homegrown perhaps as we saw in Boston and what happened in London, has to remain a top priority for federal law enforcement. And it's a good example of where what might be, Mr. Scott, a street crime, setting off an improvised explosive device, deserves and needs the federal resources to treat it. Beyond that, I think the leveraging of federal resources, which certain federal laws are important to permitting through the task force approach to things like street crime and gangs and other organized criminal activity, including drugs, which we don't talk much about anymore, which are span regions, states, are multi-state in nature or transnational in nature. I think those things are important. And then third, only the federal government, perhaps with the exception of a couple of states, has shown the wherewithal to address what I think is one of the most fundamental duties of the federal government, and that is to keep our marketplaces free and honest, because a dishonest market is not a free one. So keeping the means and instrumentalities of commerce free from fraud should also be a priority.
Mr. Shepard, do you want to chime in on this?
Well, the only thing I would add to that, sir, is that as the FBI has rightly shifted their work into the terrorism area and other areas of national importance, state law enforcement and local law enforcement has had to step in and up their involvement in cases where they might have been able to get help from the local FBI field office and they don't now because those agents are doing other things. So there's a trickle-down effect, but I think it's an appropriate use of resources and the way it should be structured. We don't need to see an FBI agent at every liquor store robbery scene. Sheriff should handle that.
Mr. Malcolm?
Yeah, if it's something transnational in nature, or if the federal government has some unique knowledge or expertise, it would be an appropriate use of federal resources. The problem is that these days it's so easy to use an instrumentality, the phones, the mail, that take you interstate, that essentially all state crimes, except for the most local of crimes, become federal crimes. And then you have problems of spreading of resources, and also a problem of accountability. The public doesn't know whether, if something isn't getting done, whether it's the federal government's fault or the state government's fault. And there's no need for that.
Mr. Benjamin?
To terrorism and international criminal activity, I would add political corruption and the denial of civil rights.
Often there's something that will raise a federal priority in a particular state is the disparity between sentences that you can get in state court versus federal court. And perhaps that's something that we can address in a further question, but I'll yield back.
Thank you. The gentleman from Michigan, Mr. Conyers.
Thank you. Attorney Benjamin, your testimony noted that almost 68 million Americans have a criminal record. And we've talked about the direct costs of law enforcement, prisons, and courts, as well as to businesses and the economy. But can you discuss what the criminal record means for the average American? How does that impact their quality of life and their ability to contribute to society and the overall economy? And how does it affect the system itself with that many people walking around with records?
Thank you, Congressman. The effect of the problem we discussed today is that we have deepened the divide between us. In a country that values equality, we have deepened the divide between our people, and we have created a caste system populated by third-class citizens who are marked by the stigma of conviction and bear a lifetime of the consequences that flow from their conviction, even after they have served their time. This is a country that once valued the right of redemption. It used to be said that once you had erred, which of course is human, and paid your debt to society, you were then free. You were redeemed to pursue life as a free citizen. But that is no longer the case. Now, after you have paid your debt, you are marked for the rest of your life with consequences such as where you can live, where you can work, whether you can pick your children up from school. That is not what this country was ever meant to be about.
Let me ask Bill Shepard. One aspect of over-criminalization is over-federalization, and how the federal government frequently intrudes on matters that should be left to the states. Is there anything that we can think about doing to minimize this? Do you have any examples that we might turn around here this morning?
Well, I think, sir, that the American Bar Association has been working with Congress for decades on this issue. In 1998, we came out with a report that involved Attorney General Meese on the over-federalization of crimes. We talked about some of those statistics earlier this morning. I think there is a natural reaction when something bad happens that we want to say we're taking action, exactly. And we're here to protect you. But part of the way the federal government can say we're here to protect you is to encourage the local state officials who already have carjacking, as you said, sir, on the books, to further enforce their carjacking statute, to give them resources they might need. If the FBI lab needs to be helpful in tracing the gun, then we use the FBI lab or the ATF. But perhaps we don't need a new federal statute. And I realize it's difficult in a position where your constituents demand action to say, for example, well, I don't think we should have a federal carjacking statute. That ends up on a mailer in my mailbox come election cycle. I understand that is a difficult position. And that's part of the reality, whether it's at the state level or the federal level or the county level. But I think the point that you raise and where law enforcement can help is to say, no, smart justice here doesn't mean more statutes. Your member of Congress is right. We don't need a new statute. And on behalf of the sheriffs and the local prosecutors, we think the laws are on the books. We maybe need funding to enforce them, but we don't need more laws. And I think coalitions like the one you see here offer some of that help and support for lawmakers when they need those issues addressed, and to have people who are experts in that substantive field help explain to the constituents why it's important that we have the laws on the books we have and not increase to add new ones.
So we ought to use this phrase a little less often. There ought to be a law.
Agreed.
I yield back.
Thank you. Gentleman from Alabama, Mr. Backus.
Thank you. Thank you. You know, I've talked to federal judges, I've talked to state judges, I've talked to criminal defense attorneys, and I've actually talked to people that have been caught in this dragnet that you described. And, you know, no one defends the status quo. I mean, it's amazing how we say we all agree. I can tell you horror stories of things that have happened to some of my constituents that you just think, this can't be true. One of the things is if you buy a piece of property and there's hazardous materials on it. I actually know of a man who bought a business, found hazardous materials, and went to the EPA and said, this is what I found. But because he didn't dispose of it in as short a time as they wanted, he was charged with maintaining hazardous material. And he served a prison term because he said, I'm not going to plead to something I didn't do. And the cost of disposing of it, he couldn't get in, he kept saying, I can't get anybody, tell me who will take this. And they want this much. I don't have the financial ability to dispose of it. He even offered the government, I'll turn over title to the land to you. He's a convicted felon. And you know, and I can tell you that causes disrespect for the law. I mean, the next person is going to say, I'm not going to look, see what's on the back of this property. It's even hard to sell property now if there's any suspicion that there might be something. So this stuff is not being disposed of because no one will buy it. So intent, I mean, Al Unser, I mean, I know of a public official who accepted a pair of shoes from a business that did work with the county, a national company. And then she thought, well, I'm not sure I should have done that. So she asked an attorney in her hometown, and he said, well, why don't you just give them to charity or send them back? So she donated them to a charity. She just gave them to him within 3 weeks, a pair of shoes. 4 or 5 years later, she was being questioned by a grand jury about did she accept any benefits or something for a certain contract. And she said no. Now, she didn't, but she had accepted these shoes. So later on, she said, you know, we need to tell them about these shoes. So she told them. Well, the U.S. attorney said, wanted to get a plea, so said, I'll give you 6 months suspended sentence, or we'll try this case. And I offered 3 years. We said it was a 3, her attorney said, you know, so she pled. Now she has a record. Let me move on to another thing, get your comments. I've been told by friends of mine, judges and attorneys, that some offenses for drug cases, if you go to the Jefferson County Courthouse or Shelby County Courthouse, if Shelby County, it's diverted. You go into a diversion program for one offense. Jefferson County, you will serve maybe you'll get a year and a day sentence max. Probably serve, 30 days, 60 days. If it's the same thing, you go to federal court, it can be 10 years. So it just depends on where you're arrested. And the third thing, and I'll comment on any of these, not little time, you know, we're not rehabbing people with this foolishness. I mean, the end result is things are much worse. You know, at least you say somebody serves a sentence, they get out, they can't get a job. We don't train them. They end up back in the system. So any comments y'all have to say, I mean, but this thing about, if the difference, I mean, and getting 10 years in a federal system and serving 8 or 9, and getting a year in a state court and maybe serving 6 months, or getting a diversion program in another county.
Mr. Bach.
Gentleman's time has expired.
Could they respond briefly?
Well, I said at the beginning of the hearing that
Yeah,
because
I know.
we're voting, I want to get to the other members of the task force before the bell rings. Gentleman from New York, Mr. Jeffries.
Well, thank you, Mr. Chair, and thank you, Representative Scott, for your tremendous leadership on this issue, and to the distinguished panelists that we have here before us. It seems to me that there are, 3 issues that we should look to tackle as it relates to dealing with the problem of over-criminalization, and I'd like to get your thoughts on those 3 different segments. The first is just the general problem of too many crimes within the federal code, and perhaps those crimes being too punitive in nature in terms of the sentencing. That's sort of broad over-criminalization. The second problem that you seem to have touched upon is the overly broad exercise of prosecutorial discretion. And then the third problem seems to be the lack of adequate counsel on the back end to make sure that when a citizen finds themselves in criminal jeopardy as a result of the first 2 problems, over-criminalization and overly broad exercise of prosecutorial discretion, there's an opportunity to actually provide an adequate defense consistent with the 6th Amendment of the United States Constitution and the Founders' intent. So if we can start with the first issue, and I'll direct this to Mr. Shepard. On the intent issue, there's sort of a sliding scale of severity. There's intentional or willful intent, of course. There's reckless disregard, commonly referred to also as depraved indifference in some instances. And then there's criminal negligence. And I'm interested in getting your comments on when, if ever, is it appropriate to have a criminal negligence intent standard built into the law?
I think that's going to be a rare case where a criminal negligence standard is appropriate. I think that's what the tort laws are for. That's what the civil court system is for, and that it's the rare case where a standard like that is appropriate. That's not to say that there aren't some where it is appropriate, and I think that the ranking member was trying to flesh that out in his question, but I think that's the rare case.
Hey,
I'd be glad to talk about some of your other issues, or we'll come back to that.
Okay, well, yeah, let me just ask Mr. Benjamin, with respect to sort of overly broad exercise of prosecutorial discretion, what are some of the things that we in the task force can look at to attempt to rein that in?
I don't know that you can rein in the exercise of overly broad prosecutorial discretion. Instead, you should recognize the powerful force that the prosecutorial function has become in our criminal justice system. That will always be the case, I'm afraid. We have very many excellent prosecutors who will prosecute appropriately, but we will always have some who in their zeal might be excessive. The answer rests with your third point. See, there will always be problems within the criminal justice system. There will always be penalties that are too harsh, conduct that shouldn't be criminalized. The safety net is the defense function. We are the safety net, the final protector of our citizens who are either unjustly accused or overly accused. And that is why it is so important and so vital that we have sufficient resources to do our job.
Mr. Jeffries, if I may, maybe we finally found something we can have a little bit of disagreement about here today. Not Mr. Benjamin's last point, but his former point. I think the task force is very fortunate to have, for example, a former prosecutor with distinguished service such as Mr. Holding as a member. Because if we look at these series of cases that the examples that have been given here, in every one of those, I think, at least on a prima facie basis, some prosecutor made a very bad decision to pursue a case. And I think looking at how and why that occurs is a legitimate area of inquiry here. And I think the answer, having been both an assistant U.S. attorney and a U.S. attorney myself, is a lack of adequate supervision, of not having supervisors, including United States attorneys, as Mr. Holding did, I can tell you from personal experience, who was willing to question the judgment of assistants.
I appreciate that observation. If I could just say in my remaining time, Mr. Malcolm, I'm encouraged by the diverse ideological group that you at the Heritage Foundation have assembled. And one of the things I'd be interested in that group taking a look at is the notion of the cost to our economy as it relates to lost human capital and lost economic productivity.
Yes, we can certainly look into that, Congressman. Very quickly, if I could just add a quick point on prosecutorial discretion. I mean, one problem is, we're a government of laws and not men. And what we should have are clear laws so the prosecutors are not left to themselves with aggressive interpretations determine what's legal and illegal. Prosecutors are people of very high integrity, but they are not disinterested people in this process. They get a lot of kudos for bringing charges and rarely get kudos for declining to prosecute.
Gentleman's time has expired. The gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. Thank you for convening this hearing, and I think this is a very important hearing. I was actually a criminal defense attorney, so I'm a conservative Republican criminal defense attorney, so and former immigration lawyer as well, which makes me an anomaly in many ways. But I just wonder, Mr. Bacchus didn't have an opportunity to have you answer the questions. Did anyone? I saw a couple of people raising their hands that they wanted to comment on his comments. I don't know if anybody wants to do that.
I really did try to address what I wanted to say, but thank you for the opportunity in terms of the importance of the exercise of prosecutorial discretion in the scheme of things.
And he also raised another issue that I wanted to raise as well. We haven't discussed it here, but as we think about over-criminalization, what about the sentencing guidelines? Do you think that's something that we should be discussing here in this committee? Do you think this is something that is leading to the problems that we're having with so many people being in prison? But what are your comments on that?
If I may, I lived through the era of indeterminate sentencing where actual sentences were determined by a parole commission behind closed doors versus the system that we graduated to with the guidelines, where sentences were determined by judges in open court, and those were actually the sentences to be imposed. Unfortunately, what has happened, I think, with the evolution of the jurisprudence on the sentencing guidelines in a nutshell is that we're sort of somewhere between those two now. We still don't have a parole commission, but since the guidelines are largely just for guidance, the disparity in sentencing has grown again. In some ways, and I don't mean this certainly as to any members here, but Congress has in essence delegated its authority to set sentences to the Sentencing Commission, and therefore, at least as part of legitimate oversight of that operation of government, it seems to me to be a very legitimate subject matter for this task force to examine.
Does anybody else have any comments on that?
Well, I would echo that and add to part of what Mr. Bacchus was saying, which is that you get different charges and different sentences in different parts of your home state. Those are driven by the local community's outrage by particular crimes, and also, frankly, by their workflow. Larger metropolitan areas often have lower sentencing for sort of regular quote-unquote crimes because they need to move them through so they can focus on the murders and the rapes and the more serious victim crimes. But the sentencing guidelines bring some level playing field to that and help defendants know and help lawyers advise their clients. here's what's going to happen to you, or here's what could happen to you in that range. So there's an important role for it, but the guidelines, as Mr. Benjamin said, also drive a lot of guilty pleas, because people know that if I'm convicted, I'm facing X number of years, and the prosecutor's offered me probation or offered me something that's going to give me that. So I'm not going to fight it. And that's where you get administrative codes and laws that never really get hashed out in the courts because the people don't go to trial.
And that's one of my concerns. I think it was actually Justice Scalia who said that we should have more trials, not less trials, that you have too many people pleading. And I think that's the consequences of having these amazing sentences where you go to your client and you tell him, well, your option is to go to trial, and if we lose, you're going to go to prison for 20 years. They're always going to choose the option of pleading to something. Mr. Benjamin, do you have any comments on that?
I do. You know, we once prized the fact that we lived in a country where we were free of the fear of unjust criminal accusation. Mm-hmm. You know, but we've arrived at a point where we've got to, every one of us, fear that the pursuit of happiness might be a crime, even though we do nothing wrong and have no criminal intent. And so that is a problem for us.
But to reclaim my time, I'm about to run out of time. But my main concern when it comes to criminal law is many times when I was in the state legislature, I had a bunch of prosecutors come in and say, well, we need to change the law because it's too difficult to prosecute this case. And I always said, good. You're taking people's liberty away. If you're going to take people's liberty away, it should be difficult for the state or the feds to take their liberty away.
It is called the trial penalty.
Thank you.
Gentleman's time has expired. The gentlewoman from California, Ms. Bass.
Thank you very much, Mr. Chair and the Ranking Member, one, for convening this task force, and I'm very happy to be on it, and I'm really encouraged by the diversity of the groups that have come together around looking at over-criminalization. I wanted to know if the panelists, I have 3 areas I wanted to cover rather quickly, and one is I wanted to know if you could comment about mandatory minimums and the, you know, frankly, the need from my perspective to change them. We had a town hall meeting in my district last weekend, and I was honored that Representative Scott came out, and we had over 200 people there talking about their concerns, many families talking about their family members that were incarcerated. So that's one issue I wanted you to comment on. And then I wanted your comments around the changing marijuana laws, you know, and what your thoughts are. We have, I mean, California changed the law, a number of states are, and then we have all of these folks that are incarcerated for very petty marijuana crimes, and I wanted to know your thoughts on that. And then I really appreciate Mr. Benjamin talking about how we did once have a society that if you did the time, you paid your debt to society, you were then able to be incorporated back. So one of the things that's happened in my state, and I imagine it has in many other states, is that we have passed all of these laws now banning people from working. So we had one case in California where in a state prison, we had a program to train you to be a barber, but then we banned you from having a barbering license. So we were able to change that, but I imagine if we had 52 examples of that in California, there are probably examples all around the country, and I'm hoping that's something this task force can examine. So, sorry.
Ma'am, I'll just address your question about mandatory minimums. Historically, the Congress prescribed the penalty in the early days of federal criminal law and said if you do X, you get Y. And that is its prerogative to so prescribe that penalty. So it's within the prerogatives of Congress to prescribe mandatory minimum penalties as part of its lawmaking authority. I do think mandatory minimums can be effective. They can be effective as deterrents. They can also be effective at removing the most dangerous of dangerous people from the street. They can also be highly ineffective if applied in circumstances where, frankly, the reason for them is far more political than it is substantive in terms of actually reducing crime.
Okay.
The American Bar Association has, as far as I'm aware, never been in favor of mandatory minimums and has spoken against them as an organization. So that's my answer as it relates to that. But I would like to answer your question as it relates to collateral consequences and reentry issues. Many states had the same problem you did in California with the barber license and the Department of Corrections training people for that. The collateral consequences that individual defendants face, frankly, I think your researchers who are trying to research the number of crimes might also have difficulty researching the number of collateral consequences. I know that because the American Bar Association, with support from the Justice Department and from Congress and other groups that have been helping us, has started a project with a website called the National Inventory of Collateral Consequences, which will be a tool that judges, lawyers advising their clients, individual defendants can look up and say, if I plead guilty to this, what are all the various business regulatory, housing impacts, student loan impacts, all those sorts of things, so that they can really make a decision that's going to be based on knowing the universe of issues. And we have already accomplished quite a bit in that regard and have over half the states, I believe, up on that website.
Thank you.
Progress continues.
I would say with respect to mandatory minimums, I would echo what Mr. Terwilliger said. Congress can certainly do them, and in appropriate cases they have their place. I do think perhaps the pendulum has swung too far and that there are too many of them and some of them are too draconian. I would say this, in these very, very tough budgetary times, the budgetary pie for the Bureau of Prisons is not growing, and all of those dollars being put into prisons is less money for enforcement and other social services. So given that fiscal reality, I think it is incredibly important that Congress focus on, one, making sure that only the right people go to prison, and two, that they are there for the appropriate amount of time and no longer.
As time expires, I'll note that NACDL during this past year has held hearings using a task force on the restoration of rights across the country, and we will soon be publishing the results of this very extensive and thorough study.
Gentlewoman's time has expired. The gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chair. I've got a statement to enter into the record.
Without objection.
Thank you. I want to follow up on Ms. Bass's questions concerning marijuana. I think that's one of the biggest problems this country has. And the problem is not marijuana, it's the enforcement of the marijuana laws and the number of people who've been incarcerated. That's the biggest problem. Has the Bar Association, Mr. Shepard, taken a position? I thought they might have on medical marijuana, but has they taken any position on incarceration for possession of marijuana?
Sir, I don't know the specific answer to your question about possession charges and prison time for...
How about medical marijuana?
I know that there is a matter before the House of Delegates that will be addressed in August that deals with some of those issues.
You don't know of any position they've taken in the past where they said that medical marijuana laws should be approved?
I personally don't. No.
Over some cocktail party where people were juggling some alcohol, they didn't talk about that sometime?
Perhaps I wasn't invited to that event.
Mr. Benjamin, what are your thoughts on that issue?
I have just been advised that we, in fact, oppose the criminalization of personal use of marijuana and certainly the medical treatment that uses marijuana. We oppose the criminalization of the use of marijuana. That's correct.
But wouldn't they take business away from you? Wouldn't you lose clients? What a noble thing.
Well, we are
so
just
unique.
We are just that noble, in fact. I mean, that is our it's true. It's true. What we want is a just and fair criminal justice system over everything else. There will always be work for us, never fear.
I value being on this commission because I think it's so important. I think other than the death penalty, there's nothing more serious the federal government could do than take somebody's liberty. And it should be, in my opinion, and I'm far from a member of the Tea Party, you know, way away, but it seems like the Tea Party should just grasp this issue because it's taking liberty and individual rights and it's using federal resources financially to just in the hundreds of millions of dollars to incarcerate, to prosecute, and then later to lose the productivity of those people because they can't get jobs, they can't get public housing, they can't get scholarships, et cetera. This is a Tea Party issue. They just haven't picked up on it yet. They need to smell the tea. And
will the gentleman yield?
if it doesn't take away from my time, yes, sir.
Well, I'll ask unanimous consent that his previous comments about the Tea Party be expunged from the record so he'll have more credibility when he goes and approaches them on this subject.
Whatever. Is the concern I've got, I'm happy to be on the committee, but I read that the Brown Commission got nowhere, and they did so much work in the 60s. My belief, and without taking on my president too much, is that the main way that we can deal with this is through pardons, the pardon power of the president, which he has not used. There's still an 18-to-1 disparity in crack and cocaine punishments. It used to be 100-to-1. Mr. Benjamin, do you think the president would be correct in using his power to not necessarily pardon but commute the sentences of those people who were sentenced to jail, federal prison, or are still in federal prison for serving at somewhere between 18 and 100 ratios, where if they'd have had the laws that Congress has passed and that therefore they become what we believe is correct and right, public policy, that he would be using his power correctly to get those folks out of the federal system?
Well, that certainly makes sense to me, but I've got to note that the exercise of the pardon power is also an exercise of a political function, and hence it's not something that we should rely upon to correct injustices and imbalances within our criminal justice system.
I agree with you, but if I was one of those people in jail, I wouldn't worry about that, and I wouldn't wait for us to pass the laws to change it. The president can do it now. And there's so many other laws that unjust sentences that he could take care of by commuting sentences, and he needs to do it. There are people rotting away in jail and causing us a lot of expense that don't need to be there, and that just needs to. As far as mandatory minimums, I think Mr. Terwillinger said you liked him. He said sometimes it's a deterrent. Do you think if there's a mandatory minimum for drug sales that you take one person and put him in jail, that there's not another person like a shark's tooth right there to take over? After 40, 50 years of the drug war, we haven't seen any reduction in people dealing because the other dealer was put in prison.
I wasn't, at least in terms of what I personally think, Mr. Cohen, would be the appropriate use of mandatory minimums, thinking of drug offenses. I was thinking of violent offenders, people who have shown a propensity to commit violence over and over again.
Thank you, sir, and thank you, Mr. Chairman.
The gentleman's time has expired. Before closing the hearing, during my opening statement, I did make a comment about the Congressional Research Service being overworked and not having enough staff to tell us what criminal laws are on the books. And we're not going to take that kind of no for an answer. The task force staff will be meeting with CRS next week and also outside experts to see if there is a path forward in this important endeavor, so at least we know the extent of the criminal law, whether it's in the 51 titles of the U.S. Code or whether it is somewhere buried in the Code of Federal Regulations. We're not going to be able to do a complete job in this task without having this information, and we're going to get the information no matter how long it takes. So with that happy note, without objection, the committee stands adjourned.
Thank you. Sorry.